and I spend a lot of time explaining this to different people. It comes as a surprise to many professionals who work with people with disabilities and to the general public. But everyone has the right to enjoy life, not just exist. What frustrates me about human rights law and the parts of human rights law I work most in is that sexual expression rights don't get much attention and are often forgotten when laws are written or when professionals are considering the needs of people with disabilities. So I try to change that, and obviously there won't be that much time today for me to give detail, and most people attending this talk virtually aren't lawyers. So I'm doing the non-lawyer version and the extreme summary version. And if anyone needs more details, my contact details are on the slides. So today I'm going to look at sex, love, intimacy, and relationships as part of the human right to have fun. And I'm going to explore how we can all work together to make sure that people with disabilities are not deprived of their rights. There are many other talks I can do. If you have an organization that needs one, then contact me. Okay, next slide, please. I usually start any of my talks with quotes from judges who understand disability rights. And you've got two on the slide here. I'll give people a moment to digest them. The first one is from a judge called Baker, who does a lot of mental capacity cases in the Court of Protection. And it's a case called TZ, a very famous case called TZ. And he says that most people faced with a decision whether or not to have sex do not embark on a process of weighing up complex, abstract, or hypothetical information. And there's a danger that when we impose a higher standard for capacity, we may discriminate against people with a mental impairment. Translation. When people choose to have sex or relationships or fun or spend time with another person or to have intimacy, they don't ask themselves 20 questions and fill in a form about whether they understand all possible risks that might happen, whether they have weighed up and understood all the relevant information. There's no quiz for people without disabilities. But people with some kinds of disability have to prove a high level of understanding before professionals will let them have any intimacy at all. Second quote there from the Court of Appeal in the case of IM and LM is on a similar line. The notional decision-making process attributed to the protected person, I'm going to translate this after, with regard to consent to sexual relations should not become divorced from the actual decision-making process carried out in that regard on a daily basis by persons of full capacity. This is largely visceral rather than cerebral, owing more to instinct and emotion than to analysis. Translation. Law shouldn't impose harder tests on people with disabilities than on everybody else. The type of decision matters. If my or your reasoning process would normally be, I like that person. I would like to know that person better. I would like to have some fun with that person. Then we shouldn't expect anything more than that, regardless of disability. Because fun, pleasure, intimacy, warmth, and relationships are all human rights. And everybody has them by virtue of being human. And everybody conscious can enjoy those rights in some way or other without the law criminalizing or getting people sued for helping them to do it. So that's what we're going to be looking at today. And obviously those quotes are in judge language, not English, but the heart's in the right place from both of those courts. They're saying we need to be careful. There are difficult decisions and easy decisions. There are decisions to which we give a great deal of time before we make them, before we decide what to do. And there are decisions that we make on a more feelings level, gut feelings level. Most people don't do checklists of several pages with complex questions and boxes to fill in before they go on a date with someone or become intimate with someone. Nobody should have to do that. And professions, including judges, shouldn't create rules that make people do so. But I've seen some of the questions that people have been asked in mental capacity tests. So people with learning disabilities in particular, or communication disabilities, have been asked questions that wouldn't be on an A-level biology syllabus. You know, most people cannot explain the mechanics of transmission of sexually transmitted diseases. Why should anybody have to pass a test on that before they're allowed to hold hands, kiss, or be intimate with somebody else? Next slide, please. So we're in a field of human rights here, and I'm going to run you through the key human rights which are relevant to fun, sex, disability. And obviously this is an area of law that I could spend about 2 years teaching, and we don't have 2 years, so it's going to be an extreme summary. But here we go. European Convention on Human Rights, ECHR, is an international standard signed up to about 50 countries, and it applies in the UK at the moment. Now, for those of you who aren't in the UK or any of the other signatory countries, then the similar rights will be found in the United Nations conventions, in some states' constitutions, and in lots of other documents. So because law doesn't always travel well, if you're somewhere else and you want to know how these rights translate to your country, your jurisdiction, ask me and I'll tell you. Send me an email and I'll tell you. So Article 8 is the 8th right down in the European Convention on Human Rights, and it's the right to respect for private life, family life, home and correspondence. Now, that doesn't sound like it's about sex and relationships, and it wasn't written as being about sex and relationships. But judges in the European Court of Human Rights, who have the supervisory role over disputes about human rights and how the convention is interpreted, have expanded those things that need to be respected into all sorts of ways that aren't written into the convention itself. So Article 8 doesn't say that there's a right to quality of life, but judges have added one in. Article 8 doesn't say that there's a right to make as many of our own decisions as we possibly can, but judges have added that in. Article 8 doesn't say anything about confidentiality, dignity, or forming and making personal relationships. But let's have a look at what some of the cases which judges in the European Court of Human Rights have decided, and see that judges have added in some really powerful human rights so that everybody, every conscious human being has the right to enjoy life, to enjoy relationships, and to explore the sexual side of their lives. Of course, mental capacity law comes in here sometimes, and we'll worry about that separately. Okay, the first case on the list there is Diane Pretty against the UK, which was actually a right to die case, an assisted suicide case. But to show you just how widely the European Court of Human Rights uses its powers, the judges in that case wandered off into sexual expression. They jumped from whether there's a right to choose how and when we die to we have other rights as well. And one of them is a right to develop as a person. And another one is a right to establish, develop, and maintain relationships with other people of our choosing, as long as they consent, and with the outside world. So everyone has a right to explore what's on offer in the world, as long as everybody consents, and as long as criminal law isn't broken. There are some things in English criminal law in particular which are illegal to do even with consent. If you need details of those, I've written lots of stuff about that earlier. So that's the pretty case. ADT is a case about group sex, which is criminalized in some countries and used to be criminalized in the UK for men, but not women. And it was pointed out by the European Court of Human Rights that that was very obviously discriminatory, which is why the law was changed. Now, I saw a question flash up just now about things being discriminatory. Oh, yes. The way that laws are applied in many countries, including England and Wales and Scotland, can be discriminatory. But you still have ways of challenging that, because human rights law doesn't come second. It's supposed to come first. All other laws must be interpreted in a way which upholds human rights. So if you find a law which breaches human rights and supports disability discrimination or any other kind of discrimination in some way, let me know. I'll add it to my hit list and challenge it, because it's so much easier to challenge it at the policy and government level than it is to challenge it every time a person with a disability faces discrimination. So go to the top, send me to the top. I'll have the awkward conversation or emails with whichever politician or decision maker is discriminating, and hopefully policy will change. I've got an example of that happening next week, which I'll try to mention later. So, on to the next case there. Back to ADT. The European Court of Human Rights said there need to be very good reasons indeed to ban intimate expression or sexual behavior between consenting adults in private. So the law shouldn't generally go into people's sexual expression rights. There needs to be an extremely strong reason. Lack of consent would be a really good reason. Somebody being unconscious would be a really good reason. Somebody being a child could be a really good reason. But the law has no general place regulating consensual adult sexual behavior in private. That was repeated in the Dudgeon case, another discrimination case, which is about the age of consent. And in X against the UK, the European Court of Human Rights said if the law does regulate consensual adult sexual behavior in private, then that law itself may be challenged under human rights. So it's not just the application, but the written law itself. Then a slightly different type of case, you've got Bota against Italy. There's a right to a leisure and social life for everyone. So regardless of disability, people have the right to, and sometimes the right to funding for, state funding for, fun in their lives. Whether their idea of fun is swinging from chandeliers, sex, circuses, basket weaving, or going to the seaside. It doesn't matter what it might be. Everyone has the right to some sort of social and leisure life. Now, it's not always easy for everybody to enjoy that, but there's a duty on governments and on people who support people with disabilities. Sorry, I'm just reading one of the comments and it's making me giggle. There's a duty on governments and people who support people with disabilities to enable and support leisure, fun, and a social life. And remember that quote from Pretty, there's not only a right to seek and make relationships of one's choosing, there's a right to maintain them. And that's one of the things which I think gets particularly neglected when well-meaning professionals are dealing with people with complex disabilities, and they let relationships dwindle out, or they put restrictions on existing relationships because they get a little bit carried away, with safeguarding or myths about safeguarding. Then on that second paragraph, you've got Articles 9, 10 and 11. So the 9th, 10th and 11th rights down in the European Convention on Human Rights are all about different types of expression. Now, I'm going to summarize these a lot because they're big, they're complicated, and there's a lot of law. But essentially, everyone has the right to freedom of expression and to receive information which enables them to make decisions in their lives. So we have the right to be informed about important decisions that we need to make. If we want to go on holiday, we have the right to be provided with information that enables us to decide where. If we want to have a relationship, we have the right to sex and relationships education to support decision making if we find it difficult to make the decision ourselves, or if capacity is in question. Governments don't trumpet these rights very much for a really basic reason. Providing information to everybody about decisions about sex and relationships and so on is a really expensive thing to do. And then if you provide information, you may have to provide support. And one of the worst things of all about people's rights to be informed about sexual expression and their relationships rights is that sometimes one word on a grant application form or a funding application form or a benefit application form, one word wrong on the form means that it gets rejected because it said sex instead of social activities or exercise. So if people wrote that funding is for exercise on forms instead of sex, or if they wrote that it's for leisure activities, they get the money. Sometimes the word sex means they don't get their money. So since 1976, when the case of Handicide against the UK happened, it's been clear that freedom of sexual expression is a very broad right under the European Convention on Human Rights. Ironically, Mr. Handicide himself didn't get to enjoy it because he got locked up for making a sex education book available in English. But since him, everybody else has had the right to express themselves about their sexuality and their beliefs and their needs, as long as they don't harm other people. And they've had the right, regardless of what their sexuality, sexual expression, or sexual needs might be. Now, there are boundaries. This has to be balanced up against other people's needs and rights. But generally speaking, there is a human right to shock, offend, disturb, and even disgust other people. It's our right to speak out and shock people about ability and sexuality and the common myths which exist about those things. English courts have also said that sex education is a human right. So if you're ever supporting somebody or know somebody who has a learning disability, which means that they've been found to lack mental capacity to make decisions about sex or relationships or any other kind of fun, then the case of CH says that there is a duty on the state, so on the government, to provide accessible sex education using all necessary and available technology and methods, so expert accessible sex education, until everything possible has been tried to support capacity, to support decision making. And this just simply doesn't happen. CH is a very sad case, actually. A couple went to their doctor because they wanted to have a baby. And the doctor was concerned that the man didn't have mental capacity. And, and so investigations started. The wife of the man whose capacity was under investigation was sent letters by the local authorities saying that she would be locked up if she touched her husband sexually again, and she'd be put on a sex offenders register. Eventually it gets to court. It turns out that the husband's difficulty with understanding decision-making about sex was about contraception. Now, they were trying to have a baby. Why would he need to understand contraception in relation to having a baby? He'd need to understand not to use it, but he wouldn't need to understand how it works. But the court said, importantly, that obviously the letters sent to the wife were unlawful. The threats sent to her appear to have been unlawful too. And that the issue with the husband's capacity could have been fixed by accessible sex education, if there was indeed an issue, because my relatively expert view on this is he does not need to understand contraception unless he's going to be using it. I don't need to understand how any particular item of machinery or computer kit works unless I need to make it operate. And I don't need to understand the details of how it works and how electricity works if what I'm going to be doing is typing on the thing rather than teaching other people to build it. So going back to those quotes on the first slide, we must be very careful not to impose higher expectations of understanding and higher expectations of ability to explain consent on people with disabilities, particularly people with learning disabilities. We need to be very careful that the law doesn't impose barriers for people with disabilities that wouldn't be imposed on anyone else. And I'm saying this as a person who, I think I have 6 disabilities now, almost all hidden. Next slide, please. So yeah, there we go, myths, the myths one. Forward a bit. There we go. One of the bugbears in my life is there are some extremely persistent myths about sexual expression, human rights, and safeguarding. And every time I give a big talk to highly educated people in the medical and social work and care professions, I get some of these myths coming back again. And the muscles in the side of my jaw here are now extremely strong from the maintaining the "I'm not remotely surprised, that wasn't a silly question" expression that I have to do when people say some of this stuff. Outsiders did a survey 11 years ago of the local authorities in the UK and whether they would fund sexual expression. And some do, even if you put the word sex on the form. And some say, no, we can't do that. We could never do that. That would be a crime. And when asked why, those local authorities said, and worryingly, sometimes their in-house lawyers said, oh, because it would be procuring. If we paid for somebody to have sexual expression with a sex worker, then that would be procuring. No, completely wrong in law. Procuring is getting someone who doesn't want to be a sex worker and making them be a sex worker. It is not paying for a sex worker to do something absolutely legal with somebody with a disability who wants that thing. So there's this very prevalent myth that it would be criminal to, for a local authority or a social worker or a carer or a care home or anybody basically, a personal assistant, to contact a sex worker for a person with a disability. The only circumstances in which that would be criminal are very narrow indeed. If the sex worker had been trafficked or was under coercion, then that would be criminal. If it was somebody who didn't want to be a sex worker, it would be criminal. And if the person with disabilities lacked mental capacity for decisions about sex and sex was had, or if the person with disabilities didn't want a sex worker to visit them, then it could be criminal. But if what we've got here is adults with capacity who consent having sex in private, it is not a crime to pay for that to happen. So that's myth number one, which I keep, it's like playing whack-a-mole or bash-a-rat, depending on which country you're in. I keep bashing down this myth. I have to put it into almost everything I write. My latest publication has it in bold and different type and giant font several times, bullet pointed, just to make absolutely sure that people understand. Don't worry about procuring unless you actually are going around forcing people to become sex workers and they don't want to. It is perfectly legal to make a phone call on somebody else's behalf or access the internet on their behalf if they have mental capacity to make decisions about sex. And if that phone call or email or visit to a website happens to be to arrange a sex worker, it's still legal. It's fine. There would have to be strange circumstances for it not to be fine. Now, there are some countries where that's not true, but it should be true. If it's not legal in your country, then there's a campaign we can have. And I have campaigns I wrote earlier. Second myth on this slide is the idea that people need to have mental capacity to masturbate. Now, capacity is a test about doing things with other people when it comes to sex. But it's really, really common for people to come up to me in the break in lectures or keynote speeches or email me and say, oh, I've just read whatever it is I've written recently, or I saw you talk, and are you sure that we don't have to safeguard somebody against masturbating? Yes, I'm sure. There is no minimum age to consent to have sex with yourself. There never has been. If nobody else is in the room, then it's lawful. But that myth also just won't go away. There's another hopefully diminishing myth, the third one down, that people who lack mental capacity for having sex, penetrative sex with another person, therefore can't have any sexual expression at all. It's not true. If they're adult and conscious, there is always something intimate they can do. And sex doesn't have to be about particular body parts. It doesn't have to be about penetration. There is always something sexual, intimate, or sensual that a conscious adult can do or can be supported to do, which will give them their human right to sexual expression. But so many people in so many countries run away from supporting sexual expression for people with mental capacity issues, that there is a massive human rights violation there. And organisations like Supported Loving, who I've worked with before, hello if anyone from there is here, face this challenge all the time, changing the misconceptions about sexuality and particular types of disability. Then the last one on there is my personal battle that I am trying to fix in the UK and in many other countries which have copied English law in particular. The Sexual Offences Act 2003, bit of legislation, says that people with mental disorders can't be helped to have sex if it's not their idea. Now, this leads people, although nobody's ever been charged with most of the offences, most of the mental disorder, sex-related offences, and that's in 17 years, not one charge for most of them. People therefore think, oh, if somebody with a mental disorder, whatever that might mean, asks me to arrange a sex worker or to give them sex education or to take them to see their partner, then I'm assisting them in having sex. Assisting isn't an offence. Making them have sex when they don't want to is an offence. I still want to abolish these offences because if you do the maths, about a quarter of the population has a mental disorder, because that includes depression, it includes people who are bipolar, it includes people with OCD, it includes the majority of people at some point in their lives. And these offences mostly apply regardless of capacity, so they are unlawful. And it's basically a Victorian category of offences which got cut and paste into the 2003 law without people noticing they were unnecessary, discriminatory, and if anyone ever got charged with them, it could be a quarter of the population and another quarter who had sex with them. So half of the UK could end up in prison for having consensual adult sex with someone with capacity. Those offences need to go. They are based on assumptions from 200 years ago that people who had any mental health issue needed to be protected from sexual expression. Human rights law now says everyone has the right to sexual expression. Even the bad bits of mental capacity law say that if you are not obviously lacking capacity, everyone is presumed to have mental capacity to make decisions, including those about relationships and fun. And so we shouldn't be presuming that people with mental health conditions need protecting from sex. Next slide. So could have done some law and stuff. And the law, the biggest problem with the law is it's so complicated that most lawyers don't know all the relevant types of law for sexual expression. So they might know the criminal law, or they might know the human rights, or they might know safeguarding law, or they might know the care home regulations, but it's kind of me, not everybody else who knows all of them at the same time. It's very rare for people to know all of them at the same time. So I'm going to summarize it all up. First point there, the rights we've been talking about: fun, pleasure, intimacy, warmth, relationships, and basket weaving. while dangling from a chandelier, in a hoist with persons of your choosing, at the beach, are all human rights for everyone who is conscious. So if it's possible for a person to enjoy those things, we need to think of whether they want to enjoy those things, find out whether they want to, and then support it. That shouldn't be anything with a stigma or fear attached to it. Sexual expression is a fundamental human need for most people. Some people don't want sexual expression. That's fine. If they prefer basket weaving, that's their fundamental human need. Also fine. However, we never say, oh, I'm sorry, but I think people shouldn't have access to food or water or shelter because of disability. We only do it with sex, not the other fundamental human needs, because sex is scary, but pretty much everybody got here through it. So it's also fundamental. Second point down, everyone has the right to sexual expression, relationships of their choosing, and fun. Now, if you could just say those things repeatedly every time someone challenges you about, or maybe they want to put restrictions on your or somebody else's sex life, or they say they can't fund it, or they make it really difficult for people to have relationships because they try and restrict them leaving a building, that sort of thing. Just say everyone has the right to sexual expression, relationships of their choosing, and fun. And if they say, oh no, not everybody, you say, okay then, everyone who is conscious, adult, consents, and does it in private. And then the third one sounds like the most straightforward of the points in the summary, but it's the one that can be the most expensive. Everyone has the right to receive information and education to support their decision-making about fun, pleasure, intimacy, warmth, relationships, and any other leisure activities. The key word is support. Now, there is a tendency in many countries to try to make decisions for people with mental capacity issues on their behalf, rather than to support the decision or to determine their true decision. Obviously, if someone is unconscious, we can't find out what their decision is. The technology isn't there yet, unless they've left a record of it in advance, stated it in advance. But if someone is conscious, then the burden is on the people with whom they're communicating to understand. The burden is not on the person who is communicating differently from the listener to do all the work. I'm very deaf, as one of my growing collection of disabilities, and it's worsening, and I don't have any balance. So people can't see that, and they assume that none of that exists. And I actually make it worse. And I've realized recently I make it worse. I enable people to make my decisions for me. And I've stopped doing it. I enable people to not adjust, not support me in going about my life. Because I lip read and I try very hard to guess what they're saying, rather than make them repeat it and make them uncomfortable. I also subtitle everything. I have a subtitling app on my phone that I subtly use when people are wearing masks. If you haven't got it and you need it, there's a free one called Otter. It's really useful, like the animal, Otter, O-T-T-E-R. And, you know, so what I'm doing is making people more comfortable about my disability. That needs to stop. It needs to stop. We need to not have to. Why should I wear a label in public that says I have a hidden disability? I have to physically wear one in public at the moment, not to wear a mask in various situations, not to be further hindered in communication, and to ask people to take their masks off. So we need to flip how we think about expressing ourselves about disability, and we need to support people to make their own decisions and never try to make their decisions for them by seeing what's best or asking their relatives. This will happen eventually. At the moment, laws in all British jurisdictions are rather behind on supported decision making, and they do tend to encourage families' views about what's best to be taken into account. Next slide. Oh yes, it's the next bit on this slide. Sorry, any restrictions on people's sexual expression rights need very strong reasons behind them and must be proportionate to their aims. Translation from lawyer into English. It's easy to say that people who live in care homes can't have visitors at night. It's easy to say we don't have a spare double bed available in this care home. It's easy to say, oh, I don't think that person's right for you. All of those are restrictions which don't have very strong reasons behind them, unless you're saying them to a child or to somebody who does lack mental capacity or is, unconscious, or in an utter emergency situation. The lawful thing to do is the least restrictive thing which would achieve what you're trying to achieve. So if you're trying to safeguard the person and the rights, then you need to do the least restrictive thing that does that. If a teenager who has a disability, regardless of the nature of the disability, if you find them at 3 a.m. on the phone in skimpy clothes, doing a video chat with a lot of other much older people, taking the phone away temporarily is less restrictive than banning it forever. Locking them in the house for a few years is something that many parents seem to try to do, but that is disproportionate. The least restrictive thing you can do, and what you should try first, is education about boundaries and behaviour. So education before restriction should be the normal approach. And then the last point on that slide, people who need support in accessing their rights may be entitled to it from the state. Next slide. Bubble wrapping. One of the things I write about repeatedly is what I call bubble wrapping. English judges tend to call it wrapping people up in cotton wool, but that's a very 20th century reference. I prefer to call it bubble wrapping because most people understand what that is. Next point on the slide. What we're talking about here is safeguarding. Now, if you look at the amount of paper produced in most countries, it would be easy to assume that safeguarding is a much more important thing to do than upholding people's rights. Because if you look at any local authority website, any professional body website, any charity website, they've all got their safeguarding policy. Not many of them have a supporting people's human rights policy. So it creates the impression, because there's so much bureaucratic paper and training and qualifications and record keeping that has to be done about safeguarding supposedly vulnerable people. It would be easy to form the impression that safeguarding is more important than human rights. It's the other way around. Safeguarding can be a human rights violation if it's not done in a human rights centered way. Now, social work professions in lots of countries have made great steps towards, sorry, my computer's just gone black, which is not useful. Yeah, social work authorities have made great steps towards this, recently by person-centered approaches to safeguarding, but it's not universal. Not everybody does. Now, I actually can't see the PowerPoints now. I don't know what's happened to my computer. When it joins us again in a second, I will stop having to do filler talking. It's restarting for no apparent reason. I love technology. But from memory, the public perception of safeguarding is along the following lines: that people with disabilities
Claire, are you still there? Maybe she needs to log in again. Oh no. Yep, she's kicked out of the room. Okay, in the worst case scenario, we may ask her to record the missing segments. Shall we just look at her PowerPoint? Hang on. Okay, she was talking about bubble wrapping. Is it me or the words cut off?
Yeah, there's some words cut off at the beginning.
The other one, the bubble wrapping one.
Yeah.
Okay. Oh, so many slides that she didn't manage to cover. Okay, I'm sorry, everybody. I don't know what to do. Sometimes technology does this to us.
Could somebody ring Claire on her phone?
Yeah. Well, she had difficulties logging on just now. You know, she is at work.
What did everybody think of my COVID question? Because that I get that all the time, especially around this subject.
Well, not being an expert, but being a man with cerebral palsy myself, I would say that the Human Rights Act should come first, because there are methods to make yourself safe from COVID-19. But I agree it is being used as a shield to reduce our rights as disabled people.
I'm fed up of it. Thankfully, Beverly and Stu still get around the problem. Sorry, Beverly and Sue, if you didn't consent to that one. Can they hear me?
Don't know. Yeah, you're off mute.
No, I'm not sure who else is on the call and who could hear, whether they can hear me to check that they.
Have they gone off?
I think Beverly and Sue can hear you. I'm not sure if
Okay,
they might.
Claire is coming back. Where's Claire again? Okay, there's no video of Claire.
Hello.
Hello.
I managed to come back the other way. Yeah, my Zoom has completely crashed and it's reporting it to Microsoft. So I'm now on my phone.
Thank
Okay,
you.
you have your slides. Do you want to continue?
Yeah, I'll carry on.
So we were up to the summary. Yeah.
Yeah, I was on safeguarding.
Bubble
Right.
wrapping.
Yeah, done the
I've got-
national obsession. Oh, I
got-
got through all those points. Right, so the result is point 4 there, that well-meaning professionals break human rights law every day because they think they must do so under safeguarding law. And this is really worrying because
Yeah, later.
it's basically it's a situation that's been created because the liability will rest with the government if there are safeguarding breaches. And so the government has papered the world with information about safeguarding and how important it is. And that's got through. They haven't done as much campaigning about human rights because it's much less likely that they'll get into trouble over that. So they have created the impression that safeguarding is much more important. Now, what can you do about this? How can you make sure that you or people you support or people who support you balance up safeguarding and human rights correctly? Well, there are resources available. One of them is from one of my other projects with the Open University Sexuality Alliance. We created documents called the Guidance and Standards on sex and relationships for young people with life-limiting and life-threatening conditions. And it's not a very short name, but I've put a link to it on probably the next slide. And if all well-meaning professionals and people who work with them, who have something to do with safeguarding and sexual expression and disability, if all those people read and apply this guidance and standards, then we'll make a dramatic change in the way that sexual expression for people with disability is perceived. And the risks that are perceived to be there will be treated in a human rights friendly way rather than in a prevent all risks kind of way. And I wrote some case studies which are available via the same link, which is I think on the next slide or the slide after that, and it will it's on one of the slides. We'll get to in a bit. Those case studies are they're all of real people but anonymized, so they're all real situations where somebody was being wrongly prevented from having sexual expression, but had an intervention through SHADA or one of my other organizations, and their situation was improved because the well-meaning professionals in their lives needed some education about human rights law. Sometimes the educational need is not for the person with the disability, it's for the people who work with or support them. Now, this is my toolkit that you've got at the top of this slide here. It's a summary of about 12 different types of law which apply in the UK. And if a person can say yes to all 6 of those things with a question mark next to them, then what they are doing as sexual expression is lawful. If any of them are missing, then it could be a crime. So it depends which one is missing and you need further advice. So you can look at the guidance and standards. There's a link to them on one of the slides and you can see what the effect is of the one that's missing. So if everyone involved in an act of sexual expression is an adult, is not involved in the day-to-day care of somebody else in the room, can communicate, does consent, has mental capacity, and is in private, then this is a human right to sexual expression being expressed, and it's lawful. If one of those things is missing, then there can be an issue. And I think these 6 points are straightforward enough that if we can get them into every health and social care and any other caring professions mentality, if we can get them used across the professions, then we change the boundaries and we make it possible for people to access sexual expression who would otherwise have found it very difficult. A few top tips here. If you work for an organisation which cares for people, particularly a residential one, and you want to facilitate sexual expression for somebody with a disability which affects their mental capacity, then it's a very good idea to have someone who is not involved in care in that facility who facilitates the sexual expression. So have somebody who is the sex and sexuality champion at your organisation. Every organisation should have one of those, and they should be self-volunteering. Have that person not involved in anybody else's day-to-day care, or bring someone in. TLC has a list of people who could be brought in as a one-off supporter who has had no involvement in the care of the person who's going to be supported to have sexual expression. Watch out for power imbalances. A lot of conversations about sexual expression don't happen because there's nobody accessible to talk to. Always keep records of how you or somebody you support who has a disability communicates. So how they would communicate about consent, because those records aren't just defensive, they're empowering. If you think back to what I said about expression rights, people have the right to receive information, all relevant information to make decisions in their lives. And that right is regardless of how they communicate. So it has to be accessible to them. Plus, mental capacity can be educated in, because it's often the case that what looks like a lack of mental capacity is a lack of sex and relationships education. The statistics are horrific for the number of people in the UK who've never had any sex or relationships education at all. Best practice regarding mental capacity is always to ensure that people make their own decisions, if it's at all possible for them to do so, and that they are at the centre of their own decisions about sex and relationships, even if they lack capacity. And then one of my particular bugbears is legal dominoes. There's this horrible tendency in cases which end up in the Court of Protection in England and Wales. So cases about sexual expression and mental capacity in particular. There's this awful tendency that if someone with complex disabilities does have capacity to make decisions about sex, people meddle in their lives by saying that they don't have capacity to make decisions about relationships or meeting new people or contact with other people. So it's what I call legal dominoes. They're chipping away at a person's right to sexual expression on the basis that they don't make friends well or aren't good at going out. This is just wrong and it shouldn't happen. But I currently am an expert witness in 5 cases where this has happened. Now that must be the tip of the iceberg. 5 cases where local authorities have gone to the Court of Protection, or in one case, the Court of Appeal, looking for guidance as to whether this is okay, stopping people going out because you want to stop them having sex and relationships, because you're worried about the sexual relationships they're having, and they have a disability. The answer is that's not lawful, in my expert opinion, which I've written slightly differently many, many times. If there are 5 cases that I'm giving evidence in at the same time in 2020, then how many thousands or hundreds of thousands of other times has it just been done and nobody's complained to the Court of Protection? No professional has thought we'd better check, we're not sure we can do this, or maybe we've gone too far. Law always needs to be interpreted in accordance with its purpose. That's one of the principles of any common law legal system, so any system like England and Wales. So the purpose that the mental capacity laws were designed to achieve was to enable people to make as many decisions for themselves as they can. It was not to restrict decision making. It was to support and enable and expand decision making. It's sometimes interpreted the wrong way round. And if you want proof of that, look at what Lord Faulkner said when he introduced the Mental Capacity Bill in a big speech to Parliament. He said exactly that. I'm quoting from memory, that it's designed to enable people to make as many decisions as possible for themselves. Then the policy you've got quoted there on the slide, that is David Blunkett introducing the Sexual Offences Act 2003, the law which creates sex offences in England and Wales, including the ones I want to abolish about mental disorder and encouraging people to have sex when they have a mental disorder. What David Blunkett said was none of the measures in this act are intended to interfere with the right to a full and active life, including a sexual life, of people with a mental disorder who have the capacity to consent. In other words, the mental disorder offences shouldn't exist because they criminalise helping people with mental disorders to have sex, even if they have capacity. My view is they only criminalise that when the person doesn't want to have sex, or when the helper has the idea first, but still, those offences shouldn't exist. And last point, I think, on this slide is avoid bubble wrapping. The process for balancing human rights and safeguarding law is the same as the process for data protection law. And a lot of people apply data protection law in a person-centered way, a rights-centered way. They get it. They can't seem to get their heads around doing the same with safeguarding. Safeguarding has to start with, what are this person's rights? Before you look at what are the risks and should anything be done about them? If so, what should be done? People with capacity, including underage people with capacity, so people who are GILIC competent, if people know what that is. People with capacity have the right to choose for themselves which risks they want to run in their lives. So if I want to close my eyes and walk down the street, I can do that. I might face criminal liability if I cause an accident, but it's nobody's job or business to stop me. If I want to do extreme sports, it doesn't matter whether I have disabilities or not. If I want to do extreme sports, it's perfectly lawful to do most extreme sports. The risks are not about the disability. They're about the thing that people are allowed to do. So risks presented by the disability, additional risks, should be managed, not managed out, not prevented. And again, the caring professions have so much trouble with accepting this because we want to help people, we want to protect people, and there is hundreds of years of assumption that all people with disabilities are vulnerable. When people say that to my face, oh, that must make you very vulnerable, I want to demonstrate my kickboxing to show that I'm not vulnerable. I usually don't, because I'm quite good at it. And I'm also a 3rd Dan black belt in jiu-jitsu. So, you know, it could be quite risky to their health to say stupid stuff about assumptions and myths about disability. Whether a person is vulnerable is individual, and it depends on the context. Whether a person's disabilities mean they need to be treated differently or better is complicated, and it depends on the context. Whether they need protecting by law depends on the context. But plenty of people with no disabilities are vulnerable and need protecting and have no laws saying that other people should make decisions for them. Okay, next slide. So I've told you that there is a document called the Standards and Guidance from the Open University Sexuality Alliance. And very quickly, this document will show you how to balance safeguarding and autonomy, safeguarding and human rights to have fun. Show you how to prevent bubble wrapping. And then the next point on this slide should be the link. I think.
There's no link. I don't see link. Maybe
Is
we can
there,
give
if you
them
press
later.
right again,
Okay, you
there
can
should
type
be
it.
more on that slide, I think.
The next slide is.
Oh, there should be more on that slide. Never mind. The link will be in there somewhere. It is in there's PowerPoint somewhere.
I don't have it.
Right, I'll have a look, see if I can get PowerPoint open on the computer. If not, we can send it round to everybody who
Oh
signed
yes,
up.
I see what you mean.
Yeah, it should be a
Okay.
blue bit.
Do you see it now? Do you see it now?
I can't, but
No.
Okay,
Not yet.
I have to ask the audience.
Not yet.
You see it?
No. Yes.
Thank
Yes.
you.
There you go. Yeah, further down in this slide, you've got.
Okay, so when I go to, sorry.
It's okay.
Class toolkit. Okay, it's here now.
Yeah, it should fly in. So, because some people need support or help with sexual expression, if we can have a massive campaign, ideally an international one, to apply my toolkit and the OU Sexuality Alliance guidance and standards, every time an issue about disability and sexual expression comes up, then we can make a massive difference, because we can set them as the benchmark, the minimum standard for sexual expression in law in every country. And that will make a massive difference to equality in the human right to have fun. And so you've got the link. It's not a very short link, which is why I put it there. Now, the project which created the Open University Sexuality Alliance Guidance and Standards has had a bit more funding from Together for Short Lives, the charity, over the last 2 years. And as stage 2 of the project, you've got a link there to lots of exciting new things that we've done. We've created interactive web-based resources about all sorts of questions that people are sometimes keen to ask but have nobody to ask, or questions that people are unable to answer in their day jobs but get asked by people with disabilities. And we've got young people with disabilities talking about their sex lives, their relationships, the challenges, what they've done about them. We've got a thing called listicles, which is a young person thing, but I knew what it was anyway. They're like clickbait. 10 things you need to know about sexual expression with a disability, that sort of thing. There are loads of videos, and the hot off the press thing is that we've done a very clear, legally compliant and accessible document, which is a sort of booklet to help people with disabilities start conversations about sexual expression, particularly young people with life-limiting or life-threatening conditions, but to start conversations with people who have not shown any keenness to have those conversations, which might be their carers, it might be their parents, it might be a residential organisation, it might be a social worker, but it's got kind of maps for conversations and scope for conversations. And we hope that it'll be a really useful tool to do that benchmarking, to get the understanding of what is lawful with sexual expression, regardless of disability, as a kind of international standard. Next slide, it probably just says who I am. Yeah, so if you want to find me on Twitter, I am unique in the world. I am the only Claire de Than, so I am at Claire de Than on Twitter. My Facebook account is old, as you can see, because it's an old style of Apple email address, but it's clairedetan@mac.com. You'll also find me very easily on LinkedIn, and please do find me on LinkedIn if you want to know what I've been up to. I have lots of projects going that people might be interested in relation to sex and relationships education, disability rights education, and various other things. And then what I've put onto these slides is for people to take away and try. So using my 6-question toolkit, Claire's toolkit, and having downloaded the guidance and standards, you've got a list of real cases here, anonymized, people who've come to me with issues about sexual expression. And your job is to apply the toolkit and the guidance and standards and see what you want to do, what you mustn't do, and how rights and safeguarding apply to each of these situations. And if you just click right on the slide again, another, yeah, see you've got in each of them, you've got a scenario and a little bit of homework. Look at what is the person's rights, what do you want to do to support their rights, what should you definitely not do, and then if you apply my 6 questions, is everybody adult, and so on, then you can work out what is the right thing to do to support sexual expression here. And there's always something that can be done for somebody who is conscious, regardless of disability, if they want sexual expression. It just gets complicated sometimes. Okay, so if anyone does their homework and wants to email me their answers, that's absolutely fine. Not many people ever take me up on that, but we could always have a little Zoom chat next week if people have tried their homework. You know, I can fit in some time there. But I think that's about it from me, because I'm going to be stealing other people's time otherwise. I know there are quite a lot of questions in the chat, or comments in the chat. So the guidance and standards, there is a small wipe clean 1-sheet version of it that you can put on the wall, and there's also a long booklet version. They're both free. Take them. Everyone is allowed to have a copy of these slides. Please post them in the Facebook group. That's fine. Yes, I like my toolkit too. when I say adults, it's the age of consent in the country that you're talking about. Some books on the politics of sexuality and disability. There's actually a reading list in the guidance and standards and in the booklet for young people on starting conversations. So help yourselves. And yes, there's also a list on LoveAbilities. Right, where else are we? Will Brexit affect Article 8 of the ECHR? No, because the European Convention on Human Rights was set up by the Council of Europe, which is a completely different organisation from the European Union, although many politicians get this wrong the whole time. So it's one of the other myths I end up busting a lot. In other words, the risk to Article 8 is from the current government saying they might bring in a British Bill of Rights instead. I think they're going to be tied up with Brexit and pandemics for a little while before they get to attack human rights. Right, we have one from Thomas. Yes, I have been doing a bit of campaign recently about the coronavirus restrictions and what I think is their unlawful application when some disabilities are concerned. I think there have been very serious violations of the human rights of people with disabilities. I've made some headway with some governments in getting them to step back on some of the restrictions. And if you want a shortcut to the information on that, if you look at Jersey Law Commission, if you Google Jersey Law Commission, I ran a conference of all the law reform bodies in the UK, plus Jersey, plus Ireland, the Republic of Ireland. And we all did papers on our concerns about the coronavirus restrictions and where they'd gone too far. So you can download all of that for free from the Jersey Law Commission.
Claire, I don't see anybody but myself. Could you, Martha, is there something wrong with this Zoom? Because I can see myself, but I can't see anybody else.
You need to look, Thomas, you need to look at participants and you can change the view. If you look at participants.
The top right-hand corner.
Yeah.
Right, I've got something from JJ, friend who's deafblind and communicates. Yeah, I need to know the friend's age. First of all, I'm assuming that they're an adult. Best thing is to email me, because this is a problem I've dealt with several times before. Managed to get an assurance from the Crown Prosecution Service that they wouldn't prosecute anybody in this situation. But my response was, you don't need an assurance because it isn't a crime as long as the person can communicate, does communicate, and does consent. But if you have to be there, I call it lend a hand, and it's one of my campaigns. If you have to be there to facilitate someone's communication, you are just replacing something that they cannot do for themselves, facilitating something they cannot do for themselves. You're not really there as you. You are part of them. I believe that legally you are not doing anything wrong in that situation, but I do have some guidance I can give you if whoever it is emails me in detail the situation, and I will say what can and can't be done.
Okay, just a moment, just to answer Thomas. So Thomas, I pinned myself because we told all the participants that we will not be filming them when we are doing sessions. So I pinned myself because Claire is, her video is not working. So that's why you probably only see me. But if you go under view, you can see gallery and you can see the other people. So it's the top right-hand corner view, that's the icon. And then when you click that, you should be able to see gallery. So this is why like my face is the biggest at the moment. Yeah, because Claire's video is not working. Okay, so coming back, Claire, this question by Nora about the Gillick competence.
Oh yes, how can we confidently evaluate the Gillick competence? I've actually written something about that. So if Nora emails me, I've got one I wrote earlier. So it's tricky, but there are actually official guidelines now, and the Court of Appeal has considered it a couple of times. Are there any more? But yes, everyone can just email me their questions. It may take me a little while to get back to them, but I promise I will get back to them. At the moment, I am in court, and I am advising people with disabilities, and I'm teaching in the evenings, and I have a meeting tomorrow morning, all at the same time, plus this. And I'd like to get to somewhere which may or may not happen. And on top of that, then tomorrow, I have to talk to a government minister about a law which he's proposed based on one of my reforms. So we're going to try and get a new body to deal with disability rights in the Channel Islands, a new official body to investigate and scrutinise human rights breaches. So, you know, it's busy. But I always get back to people when I get that far down in my email.
Yes, Tom. I'm stuck with the how to email Claire question because I can't rely on staff all the time. So I don't know how to be succinct about asking Claire what reasonable adjustment we can put in place.
I have, well, Tom, how do you want to contact me?
You know that it is not your preferred form of contact. Telephone.
Email is, but I have visual voicemail. So, you know, if you get hold of me that way, then it turns into text for me.
The problem
but that
is
makes it very stilted and slow with an email.
I want to write to you.
If you want to write to me,
I
then
can't physically do it because of my disability, and neither do I want staff to have to sit for hours and hours writing bits of legal text because you know I know a lot about this.
Yeah.
You've written for me before.
Yeah.
But I now need, well, this lady here, she doesn't want to appear on the camera, but I'm about to set up an agency of my own. But one of the stumbling blocks I have is getting CQC to understand that this practice is legal and is actually illegal not to. So I'm in London from the 26th. Are we able to arrange a meeting rather than sending emailed left, right and centre?
Yes, that's possible. So if you send me one email, give me the dates you're in London, I'll see what I can do. Yeah?
Righto, thanks.
Okay. Right, thank you everybody. I think I'm done. I'm late for a Law Commission meeting, but please do feel free to, to contact me. Yeah.
Thank you.
Thank you so much, Claire.
By all the lovely people I know who I can see there smiling. I'm waving at you even though you can't see me waving. Catch you all later, lovely people.
Thanks very much.
Bye.
Thank you.
Bye.
So,
Okay, so there is a link for feedback form for the session. Unfortunately, because of the tech issues, it wasn't great. So I will just give me a moment. Let me post the feedback form link. So every session we have a feedback form link, which I need to find. And the next session is in 20 minutes. So Barry is going to be talking about neural pathways and the possibility to have orgasms without erection or ejaculation. Okay, sorry, let me find the link and then I'll post it very, very soon. Oh, okay, let me stop the recording. So it's free and easy for now.